Hello to everybody. My name is Taya Braun. I'm the Chief Executive of the Human Dignity Trust in London. For anybody who is not familiar with the Human Dignity Trust, we are an organization that provides technical, legal, and other assistance to partners around the world who are seeking to eradicate laws that criminalize LGBT people. Those still exist, as many will know, in 66 countries today, but that's a number that's gone down quite a lot in recent years, thanks to the work of many people, using both the courts and legislatures to eliminate these laws that criminalize LGBT people. First of all, I just want to thank one of our legal panel firms, DLA Piper, for hosting us and making this webinar possible. I will give some background to the topics that we will be discussing before handing over to our three speakers, to each spend approximately 15 minutes setting out their thoughts on today's topic. And we will have time for questions and discussion at the end. So as Dan mentioned, please do add your questions into the feature in advance, and we will try to address some of those towards the end. So first of all, in terms of the background to this webinar, as part of its 5-year strategy, the Equal Rights Coalition, or ERC, has committed to contribute to ending laws and policies that discriminate against LGBTI people, including their criminalization. And the purpose of this webinar is to explore how state members of the ERC can utilize the United Nations Convention on the Elimination of All Forms of Discrimination Against Women to advance decriminalization globally, and particularly as it affects lesbian, bisexual, queer, and trans women. So as many will know, the CEDAW Convention has been ratified by virtually all countries in the world, 189 state parties, including almost all of the countries in which consensual same-sex intimacy between females is criminalized. So all of those 66 countries criminalize male same-sex intimacy. About 60% of them criminalize also female same-sex intimacy. Virtually all of those have ratified the CEDAW Convention. And the convention, of course, is monitored by the CEDAW Committee, whose views are an authoritative interpretation of a state's obligations under the convention. And that's why it's absolutely pivotal in this space that on March the 23rd of last year, 2022, the CEDAW Committee published its decision, a first of its kind globally, in favor of Rosanna Flamer-Caldera, who is a lesbian woman from Sri Lanka, who had submitted a communication to the CEDAW Committee asserting that Sri Lanka had violated her rights under the convention by criminalizing same-sex sexual activity between women. In its ruling, the committee highlighted the overlapping and intersectional discrimination faced by lesbians, bisexual, and trans women because of their sex and their sexuality and gender. So this recognition of overlapping forms of discrimination and the particularly pernicious impact that has in terms of the impact of these criminal laws globally. This case is only the second ever at any United Nations treaty body to consider laws that criminalize LGBT people. The first, of course, being the landmark Tunen versus Australia decision going back to 1994. So the Flamer-Caldera decision is historic. Not only is it the first case of its kind under CEDAW, but it's also the first case at any tribunal to focus on the criminalization of same-sex intimacy between women and the unique context and impacts of that. Although the decision is not directly enforceable by the committee in state parties, virtually every country in the world, as I said, has ratified CEDAW, meaning that that landmark decision can be used to champion decriminalization particularly in those 40+ jurisdictions where female same-sex activity is still criminalized. So it doesn't immediately lead to any decriminalization, but it can be used as an advocacy tool. It can be used in domestic courts. It can be used in a variety of ways to advance decriminalization. So we're going to be joined today by 3 fantastic speakers who are going to explore the ways in which the CEDAW Convention in general and Rosanna's decision in particular can be used to promote the rights of LGBTQ women. Alba Rueda is the current special envoy on sexual orientation and gender identity for Argentina, having previously served as the first Undersecretary of Diversity Policies of the nation. Having devoted her working life to the promotion of the inclusion of LGBTI+ people, Alba is known as a trans activist who combines academic training with considerable experience in social activism. She's also one of the founders of Mujeres Trans Argentina. Secondly, Rosanna Flamer-Caldera, who is the founder and executive director of Equal Ground, one of the oldest LGBTIQ advocacy organizations in Sri Lanka. Rosanna served 2 terms as co-secretary general of the International Lesbian, Gay, Bisexual, Transgender, and Intersex Association, ILGA, and is the co-founder and former chair of the Commonwealth Equality Network, which is a network of LGBTIQ organizations within the Commonwealth. Rosanna, of course, was the complainant and the driving force behind the Flamer-Caldera versus Sri Lanka CEDAW decision that we're discussing today. And finally, Monica Tadengwa, who is a human rights lawyer from Botswana and is currently policy specialist for LGBTI inclusion in Africa for the United Nations Development Program. She is a feminist with extensive experience in human rights and social justice advocacy, extending to regional and international human rights mechanisms. She has been a co-founder and supporter of all things Lefa Vivo in Botswana, an LGBTI organization in Botswana, which was behind the successful campaign to decriminalize same-sex relations in Botswana. And she's also former director of Pan-Africa ILGA. So before I hand over to each of our speakers in turn, I just want to highlight a few aspects of Rosanna's CEDAW decision and outline how they can be used in your diplomatic and advocacy work within criminalizing countries. So the decision was focused on Section 365A of the Sri Lankan Penal Code, the gross indecency provision, which criminalizes consensual same-sex sexual activity between both males and females. The original version, which was based on British colonial law, only criminalized males, as it did here in Britain many years ago. But it was amended in 1995 to provide equality, apparently, by criminalizing females as well. And anyone convicted of an offense can receive a prison sentence of up to 2 years. Rosanna was not able to challenge that law in the domestic courts in Sri Lanka. Existing laws are insulated from judicial review in Sri Lanka. That's relatively rare, but it is the case in Sri Lanka. She could not go to her domestic courts and argue that this law violated her constitutional rights in Sri Lanka. But because Sri Lanka is a party to the CEDAW optional protocol, which allows complaints to be brought under the CEDAW Convention, that meant that Rosanna was able to bring an individual complaint directly to the CEDAW committee. Normally, you have to exhaust domestic remedies in your local courts before going to a UN 3D body, such as the CEDAW committee. But because there are no domestic remedies, for the reason I mentioned, she was able to go directly to the CEDAW committee. And we at Human Dignity Trust had the immense pleasure and honor to assist Rosanna with her complaint, together with our team of pro bono lawyers. When her decision was published by the CEDAW committee in March of last year, it was a comprehensive and clear statement of the ways in which the criminalization of same-sex intimacy between women is a violation of the CEDAW Convention. And I would encourage you all to read the decision. It's not that long, but it's very good. And we also have briefing materials that we can share with anyone who is interested on what the case stands for. But here I will just highlight 4 key points. First, the decision is clear that the issue is not just criminalization itself, but the fact that criminalization enables and justifies a broader spectrum of injustices. So, for instance, a quote from the decision is that Section 365A, quote, has the effect of sanctioning the threats and abuse to which Rosanna and her organization have been subjected by state and non-state actors. Decriminalization of consensual same-sex relations is essential to prevent and protect against violence, discrimination, harmful gender stereotypes, all these other things that we know flow from criminalization in addition to the potential threat of arrest and imprisonment. And it recognizes secondly, it recognizes the broader injustices which are enabled by criminalization and that are particularly problematic when LBTQ women are criminalized because of the intersectional nature of the discrimination that they experience. So women like Rosanna, living as many do in patriarchal societies with strongly enforced gender stereotypes, are discriminated against both because they are women and because of their sexual orientation. And that's a particularly lethal combination. And the decision recognizes that in the unique and overlapping ways in which women experience discrimination and violence because of those different personal characteristics. So we must not forget the particular forms of discrimination faced by women when we are advocating for decriminalization. Often cases globally and discussions globally focus on the issues and the criminalization of male same-sex intimacy, but we mustn't in any of this work forget that particular impact on women. Thirdly, the committee's decision includes a range of clear recommendations that are relevant not only for Sri Lanka, but for all CEDAW signatory states that criminalize same-sex activity between women. So although it has to do with Sri Lanka in particular, it's applicable in all of those countries that criminalize. The full list of recommendations that the CEDAW committee made is worth reading, but most significant was a very clear recommendation to decriminalize same-sex sexual activity between women, and of course all criminal laws that criminalize LGBTI people, but focusing on the need to decriminalize same-sex activity between women. So that's now a clear reference point to rely on when, for example, raising decriminalization questions within UPR processes or other similar mechanisms. And fourthly, the committee includes trans and intersex women in its decision. This decision is also an indication, therefore, that the committee wants to make clear that the CEDAW Convention protects and applies to a diverse range of sexual orientation and gender identities. So on that note, and with those few words, I'd like to invite Alba to talk to us about the ways in which the CEDAW Convention has been used specifically to promote the rights of trans people in the inter-American system. So I'll hand over to you now, Alba.
Good morning, everyone. Thank you so much for this introduction, Thea. Also, thank you to the ERC and everyone who's here with us in the panel, Monica and Rosanna as well, because this is a debate that we have built together, and we would like to strengthen it using tools like this. I think it's essential for us to have within the ERC the opportunity to build tools to create a learning environment among countries and experiences. And this is such an opportunity. So I welcome this webinar. I would like to talk about this tool, CEDAW, and how it works within the Latin American context. To do that, I would like to provide a general framework regarding our context in Latin America, regarding trans and transvestite women in our continent. This is essential so that we can really tackle the concept of criminalization. Criminalization is not just the restriction within a legal framework regarding activities between people, same-sex people. There's also a larger concept, you know, socially, especially LGBTQI plus people and older people. We have lived through contexts which criminalize our existences, our practices, etc. Clearly, in Latin America, these laws that have to do with criminalization do make up this framework. But not just that. Sometimes there are regulations that are not so important, for instance, specific codes that have encompassing regulations that go against the most vulnerable people in everyday lives, and these are people that have economic and social problems. So this concept of intersectionality of our feminisms can really explain that when rights are affected, they are affected in a context, and they affect those people that are most vulnerable, that have the least access to justice. I don't know, people who live in rural areas. There is racism, and there are inequalities. People are stigmatized. So all this creates or explain criminalization. So of course we need to consider this context that especially focuses on decriminalizing a specific activity. We should also remember this wide range of situations that take place because of other minor regulations that regulate discretionally the lives, bodies, sexual orientation, and rights fulfillment of people, in particular LGBTQI plus women, so trans, non-binary, queer, lesbian, etc., and many others who fall outside patriarchal mandates. So we might consider that this has been a legal framework, and these regulations are objective, legitimate, rational. So the law helps us, you know, be neutral, and we can make claims regarding some violent acts. But we also need to acknowledge that for many years now, legal feminisms have pointed to the biases in law, especially those that apply the law within this legal framework. Many of these relationships created by these patriarchal male powers that make up an oppressive relationship concealed under so-called gender-neutral methodology. But actually, this invalidates our capacity to respect the interests of women and people in general from the LGBTQI plus collective. So law, if we say that it's a modern institution that takes on, but still takes on patriarchal mandates, and it establishes how people should be, and this is not just any quick conclusion about justice systems. It is actually the expression of one of the manifestations of power in the judicial branch. So that aims to be neutral and impartial and implement the law objectively actually includes asymmetrical practices that create within criminalization and within judicial systems a huge inequality, and it goes against women and LGBTQI plus people. Therefore, we need to remember that many of these law operators interpret and implement these regulations, and that neutrality just describes a cis heteropatriarchal system that creates terrible inequalities. This is a general concept, so that I can tell you about the real conditions where Rosanna's decision lies, because this decision and what Thea is saying about the importance of using the convention in situations like this, as in the case of Rosanna, this shows us that these legal frameworks still are essential in order to effect major changes that will allow us to overcome structural inequalities described by legal feminism. They actually say that there are unequal societies, and to strengthen democratic and governing systems, we need to fight this in court, which is essential as well. I think that Rosanna is a lesbian activist, of course, but I also want to highlight the activism of the LGBTQIQ plus collective in order to create the justice that we need in our countries. These tools are not neutral, and us, we are not neutral when facing these inequalities. Social movements can actually create the necessary real justice conditions, in particular because those of us asking for justice are the least privileged ones. Therefore, the non-discrimination principle and the principle of equal before the law are also enshrined in the CEDAW and also the International Convention against all types of racial discrimination. These are tools that have allowed us to strengthen our rights position when facing terrible inequalities. As we said before, justice practitioners work within judicial processes and follow procedures. That's true. But also, many legal theories acknowledge that legal practitioners also use the legal system selectively, and this is not new to us. We have already found tools. There's a trans author, this is a trans lawyer, Kim Spade, that talks about how these legal practitioners operate, let's say, when selecting a perspective based on gender stereotypes in order to limit people's access to rights. In Argentina, we also have this judge, a lawyer, Zaffaroni, who talks about xenophobic, sexist, and racist discriminations that make people imagine these criminal, they end up having someone's face. And those of us who, let's say, fulfill those stereotypes run the risk of being selected to be criminalized, even if we do nothing wrong. And this is also part of the context where this position occurs. Therefore, it is clear that access to justice is the main area where we need to focus, because we are now calling for using CEDAW as a tool. I would like to highlight that in Latin America in particular, we have one of the main decisions. This was issued in 2021. The Inter-American Court of Human Rights, in the case Vicky Hernandez versus Honduras. This was a trans woman and others that actually were attacked by institutional violence. And there were even, trans femicides. And the Inter-American Court echoes one of CEDAW's tools to integrate these cases. What I'm saying is, in Latin America, we have the Belén Pará Convention, which expresses actually the gender-based violence against trans women. Implementing this treaty also creates a strengthened due diligence system. In 2011, the General Assembly talked about institutional violence through negative actions and omissions that are also that also appear in state employees. So us LGBTQI plus people are victims of violence, but everywhere also we are the victims of states as well. And this is one of the items addressed when it comes to the tools we have at the UN. The Inter-American Commission, in its report against violence against lesbian, gay, bisexual, intersex people in America, also showed that gender identity and sexual orientation are not necessarily included in the Belém do Pará Convention. Still, they consider that this convention is a living tool. So the committee says that in Article 9 of the Belém do Pará Convention, they talk about the states that must consider the situation of violence that women might endure because of different factors. Then these other factors include sex orientation and gender identity. Therefore, the UN Committee for the Elimination of Discrimination Against Women indicated in its general recommendation 28/2010, although CEDAW only mentions sex-based discrimination, Article 1 and paragraph F of Article 2 and paragraph A of Article 5, we can see that the convention includes discrimination against women based on gender. So we actually do have a tool that falls within our toolkit that will help us get justice. And I'm saying this because what happens in Latin America has to do with a violence context. Unfortunately, Latin America is the most insecure region for trans women in the world. And it's the place where trans women suffer the most violence. Therefore, it's important to have this kind of tool and also LGBTI experts in order to place these tools within social movements in Latin America, and this is essential. This is not just about judicial practices, it's also a description of how research is conducted around crime against LGBTQI plus people. Therefore, we need to further analyze crimes against LGBTIQ plus people. And many times this has to do with, lack of investigation, because we don't know if the crime was committed against the victim's gender identity or not. Many times the victim's gender identity or sexual orientation is completely neglected, although it might help us find suspects or motives. And also discrimination might lead us to filing away the case, or the investigation might lead to lack of investigation.
What I wanted to highlight then is what opportunities do we have to contextualize the convention? So through this dialogue with a normative framework, the LGBTI community around the world. So in the CEDAW and in the general conventions, we have special tools that can adopt a different position regarding criminalization of LGBTIQ plus communities, especially in Latin America. But I believe that in the main principles issued in 2017, the right to truth is also a tool that we can establish dialogue on the importance of this tool provided by the CEDAW. Lastly, I would like to highlight two notions. First, to have this decision, the ruling from Rosanna, translated into all languages and socialized to all areas for organizations and social movements, so they can have a tool like this one. And a second recommendation that I would like to highlight is that the Committee for the Elimination of Discrimination Against Women is an organ of experts that work on implementation of this Convention Against Discrimination. But this committee cannot lose its perspective of gender and sex when they interpret the text. And it's essential, it's an aim for those joining us today that you share this position and to see that this group of experts also needs to have a diversity perspective for lesbians, gays, transvestites, non-binary, and so on, so that all the interpretations can be done in a broader sense. We mentioned the link with LEPU and a broader representation for this tool generated by the United Nations to the countries so that they are all harmonized. Today's intervention has to do with placing these tools in a context of deep inequalities and also to find the possibility to create a better dialogue and debate between countries, between the social movements, which are those who in the end create access to justice and to truth for our communities. My intervention, therefore, is an opening one which will allow for dialogue to take place and to add value to the ruling from the CEDAW to Rosanna. Thank you so much. And I believe that I have been respectful of the time, but I hope that I have adjusted to it. Thank you so much for the time, the space, and your attention.
Wonderful. Thank you very much, Alba. And I'll now hand immediately over to Rosanna.
Hello, everybody. Thank you, Alba. Thank you so much for your thoughts and reflections on this. I'm just really honored to be on this panel with the three of you, Thea, Alba, and Monica. Yes, this decision, the CEDAW decision was a huge decision, not just for me, but for all LBQT women all over the world. So I'm quite proud of it. It's been a long journey, though. This actually started in 2014, and it took quite a while. We only filed in 2018, so there was a lot of back and forth and fine-tuning this to such an art that the CEDAW committee could not say no to us. Yeah, what a wonderful job, Thea, and your team at HDT, the barristers who actually wrote the brief and sent it. It was all, and DLA Piper, of course, thank you for all the slog work. I mean, they had to go through all the reams and reams of paper that was sent to them and go through these things and put it all together. So with all the thank yous out of the way, I'll just take you all on a little bit of a journey, my journey. So of course, this was submitted in 2018, and I believe last year in February, the CEDAW committee ruled in my favor, which was amazing. I didn't know what to do with it, actually. I was just like so thrilled, like what's next? Yeah, things just don't fall into our lap that easy in Sri Lanka. As Thea mentioned earlier, there are actually two laws in Sri Lanka, 365A and 365 itself, 365, 365A. One is carnal intercourse against the order of nature, and the other, of course, is acts of gross indecency. Neither one of them actually have any kind of interpretation as to what these actually mean. They're all British colonial laws. Carnal intercourse against the order of nature. I think that was mainly probably put there to stop bestiality, but I think it also was pegged to homosexuality as well. And of course, as Thea said, in 1995, there was a private member's bill put in to change or decriminalize homosexuality at that time. And the justice minister at that time decided that it was gender biased, and so took out certain words like male and made it inclusive of everybody in the LGBTIQ community. So it was we just taking some large steps backwards rather than going forwards on that. So it is in that context that when this happened, it was just such a huge decision, actually, and we all celebrated. But it didn't mean that the government went ahead and said, okay, fine, we're decriminalizing, end of story. Yeah, that didn't happen, of course. But certain things did happen along the way, which, I might add, has been quite eye-opening and quite joyous, actually. So the first thing that happened after the CEDAW case was the fact that we decided to, myself and 9 other persons, we chose to have people who were not from the LGBTIQ community to join us on this case. We filed a case against the police who employed a motivational speaker to speak with police personnel in different parts of the country. And she actually proudly put all these videos on YouTube. That was one of the ways we managed to catch her. But she was just basically spewing homophobic rhetoric at the police, saying, the homosexual community is, responsible for all the child abuse that's taking place in this country. Would you like your kids to grow up LGBT? She started, getting the police to say yes, 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 or no, 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 and, rah, 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 and basically, whipping up this sentiment of homophobia within the police. I mean, like, as though they needed any excuse. They are the worst, perpetrators of crimes against the LGBTIQ community already. So they don't need this person going and whipping up all of this homophobic sentiment. So we took them to court. And earlier this year, the court ruled that, yes, they will accept a police circular that would be circulated across the police stations island-wide. Of course, what came out in the circular eventually was a protection for transgenders rather than the entire LGBTIQ community. It was an extremely valuable document, a huge breakthrough for transgender persons, because it prohibited police from arbitrary arrests, harassment, abuse of transgender persons. So, it was a groundbreaking decision. In December of last year, LGBT community members met with the IGP, the Inspector General of Police, and he actually apologized to the LGBT community for all the abuse that his police force had perpetrated on LGBTIQ persons. While we were very happy with the transgender circular, we have now opened the case again, reopened the case, and we have asked that the circular include the whole LGBTIQ community, because that is extremely important. In the meanwhile, in September of last year, a private member's bill was put forward asking to amend sections 365 and 365A of the Penal Code and decriminalize homosexuality. Earlier this year, well, actually early April, that was gazetted by the Attorney General's office and sent to Parliament. And we were very, very happy to learn that, in fact, they were asking for repeal of the 2 laws, a partial repeal on 365, changing it to a law prohibiting animal cruelty and bestiality, and a total repeal of 365A. So this is a huge victory in that sense. But of course, out came the haters. And after the first reading of the gazetted bill, 3 people from a political party that we shall not mention filed a petition with the Supreme Court saying that this private member's bill or decriminalization would impinge on their constitutional right to hate us, basically. Basically they said, oh, our religion, we should be able to choose who we associate with, and why should we have criminals being allowed to run around, and so on and so forth. So in a way, it kind of did us a favor, because many people came on and filed intervening petitions, and it sort of read like a who's who of the legal community, the medical community, the LGBTIQ community, the education community. So it was really, really amazing. And of course, we all made our written and oral submissions. The Supreme Court just came back day before yesterday saying that there is no grounds to stop decriminalization, that it is our constitutional right that we should be decriminalized, in a nutshell. And so it has given the green light for the parliament to go ahead and, start the second and third readings and go in for a vote. And they also, one important thing is that they said that it is okay for there to be a simple majority in parliament, which means that we don't need a 2/3 majority and having the whole parliament sit on this reading of this bill. So that is good news. But of course, we can't count our chickens before the eggs hatch, because there's a lot of haters coming out right now. A lot of people spewing out homophobic rhetoric on our Facebook and our social media, in newspapers, in various forms. So it is a extremely trying time for all of us activists here in Sri Lanka, because we have to face all of this, and it kind of is sometimes very disheartening, but I just feel that, let them do what they have to do. But one thing we want is that the parliament will make sure that this bill passes and that we will be decriminalized. I also want to mention that earlier on this year, the government of Sri Lanka basically made an announcement, the foreign minister made an announcement at our UPR review, saying categorically that Sri Lanka will decriminalize this year. So we've got that assurance from the foreign minister. If you notice, I'm not jumping up and down because you can never trust our politicians to do the right thing. But we just hope that, because we've been through such a horrible 3 years in Sri Lanka, everybody has suffered with not only COVID, but the unprecedented economic crisis that we have gone through here in Sri Lanka, that has basically been devastating to a lot of people. And it has caused a lot of hardship for the citizens of this country. But they can lighten the load for at least the 12.2% of citizens in Sri Lanka who are from the LGBTIQ community by decriminalizing. It's just a very low-hanging fruit. And I believe that most of the global donors who we are approaching now to bail us out from our economic crisis are making sure that they press the government on upholding human rights and the rights of all citizens to live a free and fair life in this country. So having said that, we're working hard towards organizing a huge Pride celebration this year in June, and our first Pride walk in Colombo. So, fingers crossed that by the end of the year, at least, if not sooner, we will have good news from Parliament. But it's far from over. Do I think that the CEDAW decision had some kind of bearing on, the current status, the decriminalization that's, currently on the table? I believe it has had a lot to do with it. It has also given opportunity for others to perhaps use these mechanisms and these tools to open up conversations in their countries as well. So I think certainly in Sri Lanka, there has been a lot of talk around CEDAW, but I never actually, in my heart, I never thought that it would be possible that it would have an effect with the government to decriminalize. But I think a lot of these things, take a while to play out, but eventually they do play out, and hopefully, we will get a good a decision very soon. So then, you know, I can sleep with both eyes closed from now on. Thank you.
Wonderful, thank you, Rosanna. We will all, of course, keep our fingers crossed that Parliament does the right thing and that they do it this year. And that, you know, that's not only a vindication of all of your hard work and that of many others, but that it sort of demonstrates to other countries in the region and globally that you know, the time is now to decriminalize, to clean up these laws, and to pay attention to international human rights law. So with that, I'd like to hand over to Monica Tabengwa to talk about how the decision in Rosanna's case can be used in the African human rights system. Over to you, Monica.
Thank you, Taya. Good afternoon, everyone. I also want to start by thanking the ERC for organizing this webinar, and also thanking particularly Rosanna. I think it takes a lot of courage, sacrifice to go against your own government. You risk a lot, and I think, you know, it's important that I should tell you that I'm very grateful. I'm very grateful very much, especially because, you know, we had, as Taya mentioned, there's been two decisions. We've had Tunen, but it's been a very, very long time that we've had something else coming from the international law framework, some other decision. We all remember when Tunen happened, we had very little in terms of, you know, affirmation or confirmation from any of the human rights frameworks. And when Tunen happened, I think all of a sudden we have something to hold on to, something to kind of, you know, give government something to consider. And I think we took it was upon us to popularize Tunen. And I think likewise, you know, a webinar like this is important to make this decision big, to make it work, to make it significant, and especially for me, working from the African continent, it's hopefully going to make a big difference, especially because of what is going on presently with as much opposition being presented, the anti-LGBTI movement growing, with all of these new laws being promulgated across Africa. I think it's going to be important that we have as many tools as possible to be able to hold our countries accountable, to hold our governments accountable, all decision makers, whether it's parliamentarians, judges, you know, ministers, whoever is responsible for making these decisions to discriminate against whole communities in their countries. Taya mentioned some statistics, which I think it's important to just reiterate. Out of the many countries that criminalize, 32 of these countries are from Africa. And many of these countries have provisions similar, in fact, almost verbatim similar to Sri Lanka, which were inherited from the British colonialism, and they are still in existence. And many are probably not being enforced actively, but they remain in the law books, which means discrimination is happening because they are part of the laws of the countries. So there are many different ways that, you know, here in Africa, we have been working to try and hold, or at least use international law to hold our countries accountable. And I think this decision will just really strengthen the ways that we have been able to do this. And again, these are some of the ways that Taya has already described. I think in Africa, I think, you know, most countries have have ratified CEDAW, and they regularly report, make reports to the CEDAW committee. And so, how do we make sure that countries actually, do the needful and make sure that discrimination against LBQ persons is prevented, or rather to make sure that LBQ persons are protected? And making reference to this decision, all the elements of this decision, ensuring that LBQ women benefit as much as all other women who are, protected by CEDAW. So making reference in your shadow report is important, or in your shadow reporting. I think engagements with decision makers. I think day in and day out, we talk to parliamentarians. We try to explain what international treaties are. We try to make them understand what CEDAW itself is. But this judgment, I think, is very simple, and it simplifies what the responsibilities are. And I think as you engage parliamentarians, as you engage judges, as you engage ministers, to ensure that they are responsive to and accountable for, all the actions that they take, and using the elements of this decision will be very important. I think the other thing is just really around movement building. This decision talks about intersectionality, and this is something that we have been talking about. We are trying to implement as much as possible, and now we have a decision that actually supports it, to point out the unique experiences of LGBTI women, and use this decision to show how those experiences and how the criminalization in general affects how they can access these rights. I think it's important. But one thing that is actually, we are getting some kind of good results out of a strategic litigation. In the continent, there is a lack of decisions, a lack of authorities for lawyers to refer to that affirm international obligations. And we've had such decisions in Botswana. We've had a decision in Kenya where they've indicated, for instance, they've used Yogyakarta principles. They've used a few others about the right to life and so on and so on, the right to health. And this decision again really gives another tool to be able to to refer, to make an authority that is strong enough to hold to. Just coming back to Africa, the African Charter is the main instrument that that regulates, the protection, the promotion and protection of human rights in Africa. And there are other treaties, the Women's Protocol, the Charter on Children, and so on and so forth. But the African Charter is the main one. And the significant thing about the African Charter is the fact that under Article 60, the Charter actually says that when interpreting the Charter, the African Commission, which is the body that is responsible for interpretation of the Charter, should draw inspiration from international law, particularly from the various African treaties, as well as the Charter of the United Nations, and any other instrument adopted by the United Nations and by African countries in the fields of human rights. It also says the Commission should take particular consideration of subsidiary measures to determine the principles of law. So that means other general, special international conventions laying down rules expressly recognizing by member states of the AU. And so we are talking about treaties, and we are talking about any other body that might be able to lay down law, and the CEDAW committee is such other body. And so immediately there is a possibility to link the two, and make sure that when you cite the charter, you are able to cite all other international law, including this decision. Again, the African framework in 2014 issued Resolution 275. Resolution 275 was very important because Resolution 275 is on protection against violence and other human rights violations against persons on the basis of real and imputed sexual orientation and gender identity. And so this was recognizing that notwithstanding the existence of all international treaties, the protections that exist in many national constitutions, LGBTI persons were regularly subjected to human rights violations. They were subjected to violence. And so there was a need to come up with a resolution that specifically insisted on countries putting up measures to ensure the protection of LGBTI persons. Now, if you look at this decision under paragraph 9.4, so it says the decriminalization of consensual same-sex relations is essential to prevent and protect against violence, discrimination, and gender stereotypes. Again, you see that we are dealing with the same issues. This is actually buttressing the needs to make sure, or rather, kind of emphasizing the need to protect people, LGBTI persons. And so this decision for me, it actually confirms what we have already known, that all governments have a responsibility to protect, to promote, and ensure that people access rights, whether international, whether regional, or at a national level. So Resolution 276 for me, it's important, especially when you have a lot of governments that insist that there's a division between the West or the West and Africa. We have human rights frameworks in Africa. We have the African Commission, or the African Commission acknowledging that LGBTI persons, including LBQ women, experience violence at the hands of states, at the hands of private persons, at the hands of society, and they need to be protected from such violence and discrimination. And so bringing in the two and using Article 60 and 61 of the Charter to ensure that the provisions or the ruling or the decision is implemented within the African system is important. I think, as I said, shadow reporting or alternative reporting is important. I think, like I said, a lot of the African countries have the same laws as Sri Lanka. Potentially, the action that Rosanna has taken could work, especially where there are similar provisions where you could make a communication to a committee or to a body alleging the same kind of violation. Of course, there are nuances within context, but it is an important precedent in that way. And the African Commission itself is responsible for receiving communications from individuals as well as organizations relating to violations, similarly contained in the communication that was made in Sri Lanka. So these are important considerations, I think, to think about you know, when we do our work. But I think, as I said, I think movement building and just really being able to have tools, to have something that you can hold in your hand and use. I think a lot of us have had that vacuum, you know, where you don't have enough tools to be able to work with. And so this ruling, I think this decision actually gives us that opportunity. It is incumbent on all of us, I think, to disseminate, to use it as much as possible, to expand it. Where you are responsible, such as us, myself, working in UNDP, we have a forum of judges that we convene every year. This ruling is a ruling that we can and will be using to ensure that judges discuss and learn how to use, you know, how to reason and how to use international law to protect human rights. Parliamentarians as well, you know, just simplifying it and making it possible for parliamentarians to understand basically what their responsibilities are in regards to having signed and ratified CEDAW, having signed and ratified the African Charter, having signed and ratified many of the other international and regional human rights frameworks. So I think, you know, briefly, I want to stop there and respond to questions.
Thank you very much, Monica. So we are now at the end of the discussions from our speakers, but we do have time for any questions. I think I might just kick off first with a question to each of the speakers about how you think, in particular, ERC member states and member governments should be using the decision or could be using the decision in their diplomatic efforts, for instance. Do you have 1 or 2 or 3 concrete asks of ERC member states? Rosanna, maybe I'll start with you.
Well, that's not too much of a tough question. I mean, the ask is that the Sri Lankan government needs to be responsible and proactive about, you know, decriminalizing. Now that it's on the table, now that it has been announced by the government that they are going to do this at an international forum such as the UN, I think they need to now put their money where their mouth is. There are so many areas in which they can wriggle out of this. So we want to make sure that the ERC countries are friendly and persuasive at the same time, without being overt. It's very, it's a fine line, I think, when there's also international communities asking the government to do certain things. So we need to actually find a balance. And definitely, you know, I mean, if we want, if Sri Lanka wants to be in the global market, within the global arena, I think it's time that they adhere to international norms and did the right thing here.
Alba, Monica, any thoughts, Alba?
Yeah, I mean, I think I agree with Rosanna. I think you know, ERC countries, first of all, we need to get people to understand exactly what this decision means. You know, in its most simplified version, because we do know there are many sophisticated ways that for countering everything that we say. And so I think if there's some way to develop a tool that kind of makes it very simple, 101, Rosanna decision 101, you know, where you can easily digest, because I think a lot of people, just as soon as they hear it's a court decision or a committee decision, is very intimidating. By simplifying it and ensuring that you know, it's disseminated as widely as possible, to ensure that people actually use it and understand what it means. I think that's one way of ensuring that countries, especially the ERC countries, you know, in the way that they do the work, you know, diplomacy behind scenes, it's not something that's easy. They cannot throw it in their faces. They, you know, as NGOs, I think they can, but it's the other way. So I think that way it's important, and use those countries that have done it the hard way. You know, the Botswanas and the Ugandas and the, not Uganda, Angola and I have Uganda in my brain, think what's happening there. You know, just as examples that it can happen, especially when you know, you essentially commit to your responsibilities from your constitution as well as international organizations.
Thanks, Monica. Alba.
Well, thank you very much as well for this opportunity. And I would like to give a final thought on the situation of Argentina regarding the application of the CEDAW. I think that these strategic mechanisms, and I've mentioned this during my presentation on the tool of a litigation done at the Inter-American Court, which is Vicky Hernandez versus Honduras, which is an efficient tool. But to speak at local level, I would say that one of the great efforts that the state needs to undertake, and it's clearly seen in Argentina in this inequality, is the judicial arena. So if I wanted to contextualize this tool and say that at justice level, we need a tool which is derived from activism, so that it can be sustained through tools that will be able to change the outlook. From a personal perspective, 2 weeks ago, I received a ruling against the Supreme Court of Justice in Argentina, that is to say, the last court regarding the justice system in our country. And I started this by saying the recognition of my gender identity, because in Argentina there is a law which is very good regarding gender identity, and which precisely this acknowledgement of recognition of my identity can be included in the Catholic Church. For instance, I am LGBT and part of the Catholic community. And so this has been denied because there are de facto powers which are putting obstacles on the exercise of rights of the people. And so this is a right that I cannot leave aside. I cannot drop my name every time I go into a church. And so I'm saying this not just to mention a personal anecdote, but also the topic that is cross-cutting to all of this is that the justice system is includes deep inequalities, and so they all need to be part of a legal framework for the state, but also of our own participation as LGBT people in social movements for a transfeminist justice. I think that this is the great challenge that we're facing in Argentina, and that it's not just included in issues of justice for our rights. It's quite cross-cutting how the corrupt judicial system works, and unfortunately in our country that is one of the issues where it's more visible. And we've been able to see some rulings, such as the first ruling on our beloved activist Diana Takayam, which has been because of the effort of social organizations and social movements. And so what I'm trying to say is that we need to reinforce the support to social organizations that work on strategic litigation. And this is both at national and international level. I will never become tired of saying this, that we need to establish dialogues between countries in the global south. And this is essential to share our experiences, for the rulings of Rosanna to be translated into different languages that we discussed, and that it can be placed within the dialogue with social organizations. I think the way forward is still very long. I am a civil servant from my government, and therefore I also have to state the critical situation of the justice system within my country. And not just because it's a personal issue, but also in terms of LGBTIQ+ community, there is still much to be done in terms of the judiciary. So I wanted to just mention this to mention that there is still much to be developed and enhanced in this regard. Our country has been able to see that in terms of the global south, it's essential that we strengthen dialogues. And so for this, we need to first recognize ourselves within the same inequality systems. I think there is still much to be done and a long way forward. And so it's for us, to the LGBTQ community and people, to improve our own conditions so that we can take part in this very important ruling and to have a remedy and get recognition as what happened with Rosanna. So this is my conclusion.
Thanks very much, Alba. I think just combining what both Monica and Alba have said there, perhaps a need to, we at the Human Dignity Trust have created a case digest, and that's on our, that's on our website. But even if you look at that, if it's written by lawyers, and so it can be quite technical about what the CEDAW decision actually says. And I can imagine that would be, not necessarily as easily digestible. So I need to summarize, but in simple language, what the decision says. I need to translate the decision and maybe that summary into other languages. And then I need to look at how, particularly Global South, ERC member states and other states can then use it in their diplomacy or their other efforts, so that it isn't just a decision that's just another court or tribunal decision, but it's something that people really understand and understand how and where to use it. Because as we've said, this decision is not just about Sri Lanka, and it never was just about Sri Lanka. It very much is, and we hope, as Rosanna said, that it will affect change, help to affect change in Sri Lanka with legislative reform. But it's a decision that really is about everywhere globally that criminalizes LGBT people and women in particular. So that understanding, that basic understanding of what the decision is in simple lay terms, and its accessibility in other languages is perhaps a key recommendation from our speakers. I think we have one other question about whether the recording of the webinar will be shared to the attendees. I believe so, and we can also share that the decision itself, the case digest, and ultimately, if we do some of these other steps, like summarize it in more simple lay terms, so that it can be used, with wider audiences, that we can share that with the attendees to this call. So yes, I hope we can share quite a bit at some point after the call. Do we have any other questions before we wrap up? I'll just give another few moments in case anybody has any questions about the decision itself, about what it means, about how it could be used, anything at all. We have a comment. Hello, pardon me if I'm not pronouncing this right, Ksenia Kirshenko from ILGA World. Million thanks for organizing this event. The decision is such a huge and important victory for all of our movement. just want to mention that ILGA World has resources on strategic litigation more broadly before UN treaty bodies. So in terms of strategic litigation generally at the UN, ILGA has a lot of resources. Thank you. I think those are probably the end of the, just getting a confirmation that we don't have any other questions. So we are nearly at the end of time. So I will take the last couple of moments to just thank everybody for participating in the discussion today, for taking an interest in the CEDAW decision and the great work that Rosanna has done in not only advocating on this issue in her own country, but the impact that her work has globally and hopefully can continue to have. And Alba and Monica for joining us to share their perspectives on utilizing the decision and the importance of the decision and of ongoing advocacy in this area. And a very big thanks to the team at DLA Piper, not only for assisting us in the case, but also for enabling this webinar to take place, and also to our simultaneous interpreters for helping everybody understand the discussion today in their own language. So with that, a final thank you and goodbye to everybody. It's been lovely having you all here today.